We welcome you all back, ladies and gentlemen, after a refreshing lunchtime. And our next discussion, panel 2, is on extremism and anti-terror laws versus human rights, the role of lawyers.
Our esteemed speakers are Barrister Anik Haq, Additional Attorney General of Bangladesh and Advocate of the Supreme Court of Bangladesh, and Mr. Hijaz Hisbullah, Attorney at Law, Sri Lanka. The discussion will be moderated by Ms. Swastika Arulingam, Attorney at Law, Sri Lanka and human rights activist, and convener of the Human Rights Committee, BASL. I now hand over the session to the moderator.
I warmly welcome Mr. Anik Haq and Mr. Hijaz Hisbullah to the stage. So the topic, this is known as the graveyard session just after lunch. So our job is also to keep you all up. But the topic is a very interesting topic and a very relevant topic across South Asia, but also particularly in this time in Sri Lanka, because the government is mooting a new anti-terror law. And there's several debates which are going on in the region about national security versus human rights. So today we have two very distinguished speakers, and without taking further time, I would like to introduce Mr. Anik Haq. He's a senior advocate of Bangladesh, enrolled in 1999, and he was elevated to a senior advocate in 2025. He practices across judicial review, public interest litigation, family, civil, commercial and criminal law, and has represented major institutions including the Bangladesh Telecommunication Regulatory Commission and the Central Bank of Bangladesh. He has participated in numerous international arbitration cases and continued to key legal reforms as a member of the drafting committee of the Electronic Commerce Act 2006, the Bangladesh Telecommunication Act 2001, and the International Long Distance Telecommunication Service Policy 2007. Alongside practice, he has held academic and administrative roles linked to the University of London and is widely recognized as a human rights lawyer for challenging abuses of power under anti-terror laws and defending victims of arbitrary detention and political persecution. He currently serves as the Additional Attorney General of Bangladesh and hosts Ain Kanun, a weekly live legal call-in show on Ghazi TV. Over to you, sir.
Good afternoon. Best thing about having this session, that all of you are very satisfied with the lunch and not much question to ask. So on that note, let me start. I was always a lawyer. When I started practicing, I started with the idea that I'm going to do the world some good. And so it became an everyday struggle when I saw that our government is abusing the power they have and fight against it. Last year, on 5th of August, Bangladesh have gone through an uprising, and the previous government was uprooted, and a new government, an interim government, which is not a political government, I must remind you, came into power. And at that point of time, I was asked to become Additional Attorney General. And I said, I have always fought against the state. Now, how do you expect me to do something which I've always been against? The answer that I was given by our current Prime Minister, that is Chief Advisor, we call him, said that because you have fought against the system, you know where to change it and how to change it. I'm giving you complete freedom so that you can do that. So we have done certain things. I will come one after another, and why it never happened before and why it is happening now, and what, as a lawyer, we can do to change it, or how we have struggled and finally have succeeded in doing this. I believe we all have our roots of laws from the British English legal system, right? The Commonwealth, because we were all part of the Commonwealth and all that. So we have inherited the same CRPC, the Code of Criminal Procedure, with the draconian Section 54, the system of remand by arresting somebody without any cause, detaining without cause, and then, of course, the torturing. Along with those, in Bangladesh, we have had a very interesting law called the Anti-Terrorism Act 2009. If anyone go through the definition of the Terrorism Act, the terrorist acts in that particular statute, even if I say good morning to someone, that might be termed as a terrorist act. This is drafted in such a broad manner. So we filed case after case after case against these, that this is not constitutional, this is completely unconstitutional and all that. Nothing happened. So when I came into my office, we started looking into that, what exactly was being done with this act. We found out that since 2009 till 2024, this particular 15-year period, about 21,000 cases were filed on mere suspicion that this person might be a terrorist. Why? Because he was carrying a book which is suspicious. Now, there was no list of books that these are banned or anything, whoever they wanted to. So this basically became a tool for oppressing or for harassing the opposition political leaders. Then, back in 2015, they came up with another interesting law that is called the Information and Communication Technology Law, where if you publish something in the web, and if the government thinks that this goes against their interest, they will term you again as a terrorist and they can arrest you. We filed, and immediately we filed a judicial review saying, no, this is basically trying to curtail the freedom of speech and expression. So what they did do, they waited, and in 2023, the section that had that particular offense in the 2016 Act, they just sort of like divided them into 7 parts and made 7 new sections, and taking credit that we have repealed the old Act. So it was basically what I would say, old wine in new bottle, the same thing. So again, we challenged that. And that case is still pending, but after 5th August of 2024, we absolutely scrapped those sections, said that no, these are not offenses at all. We do not care about that. Now let's get back to the 21,000 cases which were filed there. We started finding each and every case out, and within this 1 year, we have actually, with our office's opinion, dismissed about 16,000 of them. That these cases has no merit. This was just filed simply to harass people, and this. But this was the case side that we are doing, telling you. What happened that there was this Section 54 where police could have arrested anyone, detain anyone without showing any cause for 30 days. And within these 30 days, they could have been taken into custody and remand. Remand is, in Bangladesh, remand is a very dreadful word. It was a very dreadful word, that people were arrested and then tortured to get false confession and stuff. This one particular case, which is known as the 21st August grenade case, this one I will just give you an example of this, that in 2004, on 21st August, during a political rally of Awami League, the fallen regime, there were grenade blasts and 3 people died. In 2004, interestingly, the party in power was BNP, the other party. So Awami League was then the opposition party. BNP started investigating it, and then in 2008, BNP got ousted. Awami League came in. The moment they came in, they said that no, that investigation was not done properly. we are going to reinvestigate it. Fair enough, they started reinvestigating it. One particular person called Mufti Hannan, he was a religious leader. He was arrested in some other case and was in his condemned cell for about 3 years. He was brought back and made to give a second confession while he was in custody. After about 3 years of custody, he was forced to make a second confession, and based on that, 21 persons were sentenced to death. That appeal, after all these days, back in 2024 December, we conducted the appeal in the High Court division first. And the High Court, after going through everything, said that no, the way the first investigation was done and the second investigation done, both were done quite illegally. No legal procedure has been followed. So the High Court simply acquitted all 21, those who were sentenced to death. And as state, we have to sort of like make an appeal against that. So we filed an appeal. And when the appeal was being heard, I just stood up and said that if a single day these people are being kept in the prison, that will be a travesty of justice. Because not one single police procedure was followed during the investigation. And if anybody goes through the judgment of the trial court, you can see that how politically motivated this whole judgment was. And I quoted Nani Palkiwala, one of my all-time favorite lawyers of our subcontinent, that it is always desirable to inject justice into the political system, but in our subcontinent, regrettably what has happened that politics was injected into the justice system. So this is something which we must all be aware of. And that is why when I started, I said the current government, mind you, is a non-political government. So this is the time when we are actually trying to do some good reforms if we can. So as I was talking about Section 54 and the remand, back in 2003, I was a very young lawyer then. I filed a case challenging that this Section 54 of the CRPC, that arrest without warrant, and the subsequent police procedure under Section 167 of the CRPC, that is about remand, all of these are unconstitutional and has to be reformed in a proper manner, so that even if somebody is arrested, some accused, he also has a right. His right to be treated in accordance with law and only in accordance with law cannot be taken away, the constitutional right that he has. And after hearing, this case was actually, I filed that in 2001 and 2003. This case was finally heard and judgment was given. 15 guidelines were given. 15 guidelines were given about after what happens after arrest, whether they can keep him or not, and what has to be done. These were all coming out of the British Police and Criminal Evidence Act, that if you're trying to ask somebody a question, it has to be in a transparent room with the lawyers present. There has to be a right to a phone call, and of course the Miranda warning and all that. All these things came in, and the High Court gave directions, 15 directions, that this has to be done. The government appealed immediately before the appellate division. The appellate division, that is our Supreme Court, they upheld that decision of the High Court, saying, no, these are all proper guidelines and you have to follow it. That came somewhere in 2015. Thereafter, government filed a review and didn't do anything, just kept it hanging. Whenever we used to say that there are these guidelines, why you are not implementing it, the only explanation they came up with is that this is under review and we don't want it to be done right now. Again comes August 24, 5th August 24, and this time I could not do this case because I was on the other side during my previous career. And the appellate division said in the review that no, all this has to be there. And taking advantage of that, on 10th August 2025, we completely done away with Section 54 arrest and the torture in the remand, or we have given the procedures, what has to be there in the remand. Now police cannot question anybody without the presence of a lawyer, and that lawyer cannot be the lawyer of police's choosing. It has to be the defendant's lawyer, and his family has to be informed right then and there why he has been arrested and all this, and this has been used quite extensively. Another interesting fact that in Bangladesh we have had cases of enforced disappearances and something called crossfire killing. Crossfire killing is sort of like the police arrests you and then they shoot you. Encounter, I believe, is called, that's called in India, that the police will arrest you and then come up, they will probably kill you in the cold blood, and then they will issue a statement saying that, oh right, when we were taking him, there was this attack from the other side, and while we were trying to defend ourselves, the person died in the crossfire. Since 2001, the total number of crossfire killing was somewhere around 9,000 in Bangladesh. Yeah, people's lives in Bangladesh are really cheap, believe me. So 9,000 people were killed in crossfire, and the enforced disappearance is about, for last about 10 years, that's a new phenomenon, but for last 10 years, it was about something around 700 this, and all their families still keep on crying where their parents are or where their family is. About 10 or 15 of them have been found. They were kept in a room and all this. But since 5th August 2024, the number of this sort of cases is 0. There has been no cases of enforced disappearance nor any crossfire killing. We have completely barred the police from doing all this. Police and definitely the army. So why did this take place for all these years? One reason I think that probably goes, I don't know whether it goes for the rest of the subcontinent, that we are very tolerant. We endure injustice and unfairness with some feudalistic servility and fatalistic resignation. And until and unless our backs are absolutely against the wall, we do not react. The thing that happened in Sri Lanka a few years back actually paved the way. Bangladesh followed the trend, and last is Nepal. So what can we do about this? My only advice about this is, in Bangladesh, we take an oath while we become an advocate, which makes us oath-bound to fight against every social injustice. And those of us who have practiced public interest litigation or these human rights cases, we have always believed in that. And very interestingly, in one of our cases, where a lawyer, being a lawyer, a case was filed, and the court said, the other side said that, where is the locus standi? And I said that locus standi is there because I, as a lawyer, am oath-bound to take steps if I see social injustice, and a great social injustice is being done here. So I think I have it. And very interestingly, in Bangladesh, after that case, the judgment came out and said that any lawyer anywhere in Bangladesh can file public interest litigation if he sees some injustices being done. So that is one sort of breakthrough that we made in that area. And again, I'm a very apolitical person. I really don't like politicians or politics, as you can understand. So what I would say that all the laws of all these countries, our countries, Bangladesh, Sri Lanka, Nepal, India, Pakistan, our laws were basically made that we could make our country a land of opportunity. But what actually we managed to do is we have made it into a land of opportunism because of the politicians, the way they have done this. I believe if Machiavelli was born today, he would have been out of his job because of his naivety. Our politicians have outdone him long back. And another last part I will say that is again comes back to all of us and our politicians, that our political values have become so debased in last 15 years that while it needed courage to do the right thing, but it never needed any courage whatsoever to do the wrong thing. Finally, the Bangladeshi people had the courage to do the right thing and oppose the tyrannism, and there you are. Thank you.
Thank you, Mr. Haq, for that insightful presentation. And I'm sure many participants in the audience and young lawyers in Sri Lanka would see the parallels between Sri Lanka and Bangladesh, and particularly the part where you said we don't actually resist until our backs are pinned against the wall. I think that's true in many South Asian countries. So thank you so much. Our next speaker is not a stranger to many of us here, Mr. Hijaz Hizbullah. He's an attorney at law, and he's well known for consistently and persistently taking up cases not only in the Supreme Court but across the judiciary with regards to civil rights, civil liberties, but also in terms of the Prevention of Terrorism Act and so on. And many of us here believe that it is because of his activism that he was targeted and persecuted by the state, and he was arrested and kept in detention for nearly 22 months under the Prevention of Terrorism Act. The Amnesty International called him a prisoner of conscience, and I think that's fitting for the experiences Mr. Hizbullah went through in detention. I don't think there is anyone better here in terms of Sri Lankan lawyers to speak about the abuses and use of anti-terror laws and the tensions with human rights and anti-terror legislation, the tensions between these two fields of law. So over to you.
Thank you, Swastika. I am also appreciative of the challenging time slot that I have been given post-lunch. And also before I begin, I must also congratulate and thank Barrister Anik Haq for the tremendous work that you're doing. I mean, I'm really grateful that you have used your office to amend those laws and to give relief to the people of Bangladesh. And that is certainly a lesson that we in Sri Lanka can learn from our neighbor, Bangladesh. And I must also incidentally say that my great-grandfather is from Bangladesh. He's a Bengali. Because there were Bengalis coming to Sri Lanka and setting up businesses here, and so there's a bit of Bengali blood in me.
That's what it shows where you got your...
Yes. Right. So in my presentation today, I will be focusing, I'll spend a little bit of time talking about the PTA and how the PTA, the challenges that an accused or a suspect under the PTA faces vis-a-vis any other person accused of a crime or an offense in the legal system, and how they are substantially deprived of their procedural rights. Thereafter, I'd like to talk about the role of lawyers. How do lawyers help, and how can lawyers help? I'll also like to talk about the problems that lawyers face, and thereafter, I think maybe conclude as to how bar associations and legal communities can help lawyers and thereby suspects and detainees in dealing with this type of situation. So Sri Lanka has had the Prevention of Terrorism Act number 48 of 1979. It is titled Temporary Provisions, but we have had it for over 45 years. It was titled temporary provisions because originally the government introduced it only for on the basis that it will only be used for 1 year, and also the government at that time admitted that it did violate the constitution, but gave a certificate that it will be passed with a 2/3 majority. So it's an admission on the part of the government itself that the PTA does violate human rights. So there is no debate about that. But I do not think anyone foresaw the extent to which the PTA actually violated human rights. The offences, offences of under the PTA are defined under section 2, and if you read it carefully, there is no difference between a PTA offence and an ordinary penal code offence. It's the same thing. There are slight differences. For example, they have definitions of what is called a security area, a specified person. So those slight differences are there, but offences that can be prosecuted under the PTA can also be prosecuted under the penal code, and offences under the penal code can also be prosecuted under the PTA. They overlap. But this is where the human rights issue comes in. This is where the human rights issue comes in, because the procedural regime that is applied for a penal code offence and the procedural regime that applies for a PTA offence are completely different. All the rights that a suspect has under the penal code regime or the ordinary criminal procedure code regime are completely taken away under the PTA. And who decides this? A police officer. A police officer will decide whether the good morning usage should be prosecuted under the penal code or whether the good morning usage should be prosecuted under the PTA. With no judicial officer, technically and theoretically, a judicial officer could, a brave magistrate could review that. And we have had isolated instances of a brave judicial officer actually reviewing the charges and discharging, but even by that time, the suspect has spent considerable amount of time in custody. We have the case of, I think the recent PTA, the most recent PTA case we are talking about is the case of Mohammed Shuhail from Mavanella. Mohammed Shuhail from Mavanella, he was living Mavanella, I think, for our foreign friends, friends from abroad won't be familiar with where Mavanella is. It's a few kilometers, maybe 2-hour bus ride from Colombo. It's a beautiful village. And so Shuhail was not interested in a boring career of law where you sit inside a courtroom most of your day. He wanted to have a far more interesting career. He wanted to work in an airline as a cabin crew, work in a cabin crew. And so he wanted to come to Colombo and start training to join an airline. And so he was looking for an accommodation, and then he walked down a road on a building where the Israeli government had some interest, and so on and so forth. There's a long story. The only thing that was there for him was that when the police questioned him, he did not have his identity card in his possession. That's the only thing. He was on a road where there was a building in which the Israeli government had an interest, and when the police asked him to identify himself, he did not have his identity card with him. That's all. At that moment. Where was the identity card? I think a lot of people can relate to this. I certainly can. It was in his trouser pocket. In the trouser he had worn the night before, and which he had removed and kept it at home. And he had walked out without carrying it. The ID was found a few hours later. His mother found it, and they were able to. But by that time he was arrested and he was taken to the police. The police produced him initially before the magistrate. The magistrate found it all this nonsense, released him immediately. He stayed overnight and then produced before the magistrate. Magistrate released him overnight, immediately. He went home, and when he got home, he saw the police jeep parked outside his house, and the police said, no, we want to question him again. He was brought to Colombo, produced before another magistrate 3 days later, and there was nothing that the magistrate could do, because under the law, once a superintendent of police gives a letter a written authorization saying that this person has been arrested under the PTA, the magistrate has no option but to remand him until the conclusion of the trial. Conclusion not of the investigation, conclusion of the trial, which is, of course, he's looking at 15, 16, 17, 18 years. Well, we'll come to the role of lawyers. I think he was lucky that he had a group of lawyers who appeared for him and who fought for him, and also the role of social media. He was in custody for 9 months. His parents were silent, quiet, did not approach anybody because they were worried about repercussions for their child. But having run out of patience, after 9 months, they went to the media and they started talking about it in social media. And the father tells me 20 days after the first tweet, his son was released. His son was released subject to certain conditions, and I think on the 16th of September, that's I think Tuesday, the magistrate released him of all charges. Released him of all charges. So here we have, and this is just one case, and we have so many, the Sri Lankan lawyers here, Mr. Lakshan Dias certainly will know about this. There are enough cases of people who have been arrested and kept in custody for a long period of time with absolutely, and then released without any charge. I'll just give another little incident of somebody who was in detention with me. He was arrested, and then he was charged, accused with 2 others. And when he says he saw those 2 people for the first time, so they were supposed to have aided and abetted and conspired together, but he said, I saw them for the first time in the CID. So basically he was a wrong person, arrested for the wrong reason, but the CID was not interested in admitting its mistake, so they just pushed him off and parked him with the others. And they were there. After 17 years of, he dropped his daughter in school, kindergarten. He dropped his daughter in kindergarten in Vaunia, took the bus. Sorry, he dropped his daughter in Vaunia in the kindergarten and then took the bus, went somewhere, and that's where, when he got off the bus, he was arrested. After 17 years, his trial was being conducted, and then the defense was called. He got on the box and to give evidence on his behalf, and then he was narrating his story as to what happened to him on that day when he was arrested 17 years ago, and he told how he dropped his daughter in the kindergarten and he got in the bus, etc., etc., etc. The judge obviously was horrified because he suddenly realized, with all the evidence that was led, that this was actually an innocent man who has been in custody for 17 years. And then he asked him, why didn't you tell this before? Why didn't you tell this before? And my friend Sam's reply was, he broke down at that point, was, when did you ever give me a chance? Under the Prevention of Terrorism Act, when does an accused ever get a chance to tell I'm innocent? He was released, and I was very happy that a few months later, I was also released, and a few months later, I got a WhatsApp message from my friend inviting me for his daughter's wedding. For his daughter's wedding. So here, I was at least happy that he got that opportunity, that the daughter he dropped in kindergarten had grown up and was getting married, and he was there to conduct the wedding for him, which of course he was talking to me when we were inside together. So you can be arrested for anything. Not only can you be arrested for anything, then you can be arrested for being suspected for having done something, and then for aiding and abetting and so on. So it's a very broad spectrum of factual circumstances that you can be arrested for. With your arrest then comes a detention, which until 2022 the government was allowed to keep people in detention for a total of 18 months, which has now been reduced to 1 year. With 3 months at a time they have to get a detention order. And thereafter we have the question of a trial. In trial, all PTA cases have one common feature, which is a confession. A confession obtained during detention. Often under circumstances of torture, but you do not have to torture people to get a confession. All you have to say is, do you want to be in custody for 25 years or go home tomorrow? Because being in custody for 25 years is a reality. It's a reality. Because under the law, you're in custody until your trial is over. So 1.5, so how that 20 plus years comes in is, you're arrested, 1.5 years detention, remanded, there's no bail, then Attorney General's Department generally takes 4 to 5 years to file your indictment, then the trial commences, that takes at least 10 years for the trial to finish. So that's how your 20 odd years falls in. So they ask you, do you want that, or you want to tell us something and we will let you go? And so then the confessions come quite easy. Confessions are not accepted under certain circumstances under ordinary law, but of course under the PTA, a statement given to an ASP, where even if it's not a confession of whatever nature, can be accepted and laid in evidence. What's also draconian about the PTA is that a confession made by somebody else can be used against another person. So that's where we had I think same thing in Bangladesh, where the Mufti can give a confession and put 25 others in custody, in the death penalty. So, if I may just share a little bit about my case, right? So I have the honor and the privilege of 10 people coming out publicly and on the media. That's all there. It's not what I'm making up. It's all there. Just Google my name and you'll have all that. Saying how the police coerced them and intimidated them and tried to bait them to give confessions against me. So all what they were looking for is some weak link somewhere, somebody who can be coerced to make a confession, and then they use it. That can be used to convict me. Even though I have not confessed to anything. And under the law, it can be used if that statement can be corroborated in a material sense. And what that material sense means, so we are all here in this room. So where were you on the 21st? I was 20th, where were you? I was at home. Then what did you do? I got ready. Where did you go? At the bar. So what happened? All that's corroborated. Was so and so on the stage speaking? Yes, that's also corroborated. Everything's corroborated. And then he'll say, and then he said, do this. Now that's a lie. But that's a lie. Now that's the lie. But then it's corroborated. Everything else is corroborated. Therefore, that's confession is valid. Also under the PTA, a statement once given to a magistrate by anybody, any witness, can be used as evidence in trial, even if the witness comes in trial and says, I was forced, they forced me to say that's a lie. So the police can take you to a magistrate and say this. You say it because you're under so much of pressure and coercion, and you come out. And then few years later, when things have changed, you're in the High Court, you go to the High Court judge and say, well, you know, that's not true, it didn't happen. Still, the judge can act on what was said to the magistrate and not on what he said in front of you. So that's how bad a trial under the PTA can be. It completely removes all your rights as a suspect. And convictions are very easy, but we are also very happy to note that despite all of that, PTA convictions have also been not very high. And I think that's because of the tremendous job that the legal community has done, and the vigilance of the judges. But that cannot rule out that those other convictions are seriously in doubt. A normal detainee under the PTA either comes from a lower middle class family or a socially underprivileged family, is a sole breadwinner, not much in terms of education, financially not in a great shape, And then you can imagine putting that person behind bar for 20 years and how the family is going to deal with that situation. And this is where the role of the lawyer is so very important. So very important. I mean, as lawyers, we all know how we do not end up just playing a professional role, especially trial lawyers, litigators will know that we do not just play a professional role, that during the course of time, we also become friends with the family. And if you watch the famous Indian movie Jai Bhim, you will see, and any movie on lawyers, how lawyers start playing. And this certainly is the case for PTA. I won't be here, I must say, if not for the amazing battalion. I was not a team, I had a battalion of lawyers who represented me and who were working day and night on my case. Day and night on my case. My good friend Hafil, Mr. Farman Kasim, Mr. Niran Ankitel, and Mr. Kanesh Yogan. They were the ones who really got down and went all out, and it's because of those lawyers that we were able to get that far. Lawyers, number one, when you're a detainee and when you're behind bars and you have these police officers telling you, we lock you up for 20 years, having that friendly face, visit you and tell you, look here, don't lose hope, we are fighting for you, goes a long way. Number one. Number two, the lawyer also is the one who will tell you and help you decipher through the code of messages that are being thrown at you by the police and the people who are detaining you. And of course, the lawyer is the one who will be able to fight for you in court. Swastika, am I going too far?
No.
How far? I have a bit of time? Yes. All right. How much time? 5 minutes, okay. So, we need to, as bar associations and as legal communities, protect the rights of lawyers, particularly with their right to access their clients. Today in Sri Lanka, we don't have the right. It's not easy to access a client who's in PTA detention. You have to write. You have to write to the prosecutor. You have to write to the detaining officer. He has to then consent to you seeing. Until 2022, there was the right to representation, right to access lawyers was not recognized. After the 2022 amendments, that right has been recognized. Even if the right has been recognized, there is no confidential access is not granted. Those conversations are monitored by the police. I think it was it was in the context of the consultation that I was having that we went to the Court of Appeal. Dr. Romesh Tisila appeared for me, and we got an order allowing for confidential access. And then we had the meeting of the confidential access, and we walked into the room and we looked under the table and there was a mic. And not only did we find a mic, we also found so many cameras. I mean, they are also quite a bit stupid, okay? So we had about 5 lights on, and there was a 6th light, because they came and said, they told me, you sit here. So I sat here, but I knew there's something going on. So I just sat there and I said, the first thing we do, look under the table, and there was a mic. And I looked at the table, that light was switched off, there was a camera inside. So confidential access, because what was happening was that police was filing reports in the magistrate's court, making accusations against me. My lawyers were coming in, talking to me. These guys were listening in. I was telling him, no, that's not true because of this. That's not true because of this. These are lies, this lie, and I'm setting out my defense. They listen to that, and then they polish up their fabrication, becomes better. So we realized this. The first or second consultation, we realized this was happening. I said, no, we are not going to have any more consultations with any police officers, even nearby. I mean, they just stand somewhere there. We are not going to do that. Completely confidential access. And then that's all. But recently, an attorney at law, Mr. Shifan Mahroof, went to the PTA, went to the CID to speak to a suspect. He was not granted confidential access. He protested against this. They then thereafter recorded a statement from him because of that. And I was happy to know that the Bar Association has also written to the CID about it, to the Inspector General of Police about it, and very happy to note that the Bar Association is saying that these PTA detainees are very vulnerable and require robust protection. Furthermore, lawyers also face the challenge of smear campaigns, where even our own legal community starts smearing lawyers who appear for suspects, and we need to grow up as a community based on that. As far as legal, yeah, I think I'll end with that. Thank you very much. I have a bit more time? Okay, I have a few more minutes. With regard to international standards, how can international standards help us? Frankly, Swastika, we live in a time where we talk about the Genocide Convention, but we allow for a genocide to take place in Gaza. So I'm not very enthusiastic about international standards because even when we had the anti-terrorism bill was being argued in the Supreme Court, most of the examples that were coming out and that was presented by the state were examples of incidents, of terrorist incidents that happened in some other country, not in Sri Lanka. So I think we need to be very careful about international standards, because with that also coming international security measures that are unacceptable and that do not meet the threat threshold in Sri Lanka. Thank you.
Thank you so much, Jazz. When you were speaking about the low rates of conviction and the fact that the judiciary is very vigilant, I was reminded of the case of a few exceptional cases like Nallaratnam Singharasa, where to date he maintains that he was tortured into giving that confession, and up to the Supreme Court they refused to discharge him despite the fact that there was an ICCPR recommendation and so on. So one of the things about PTA is, I think Hijaz and even Lakshan, we always say, we don't need a PTA, a sweeping law like the PTA in Sri Lanka. But that position is not a popular position. And one of the reasons for that, I think, is people think they will never become, they are not the subject of PTA. But as long as PTA remains in democratic countries and anti-terror laws remain in democratic countries, we are all suspects. That is the reality, I think, we have to keep in mind as lawyers, I believe. Right, we have some time for questions. Where is the mic? Yes.
I have a question both to answer in combination to Hijaz and also to Barrister Atik. Now, in case we do away with the PTA, I mean, I'm also of that school of thought, and I've had discussions with Swatika also on that for years. Do you think in both countries and also now regionally, we are showing the same ripple effect after taking very proudly the so-called revolution we had? The rest of the region also is following suit in different other aspects. Do you think if and when we do away with the PTA, because as Hijaz said that in the penal code itself we have certain provisions, and even in Bangladesh, because there had been a lot of also with the Rohingya crisis, and there are so many other things that Bangladesh has to handle very turbulently regionally, which Sri Lanka doesn't have at the moment. Are we sure, not are you, I'm also of the same school of thought, are we sure that we can completely manage without it in two occasions in the current context, and also with some of the turbulence that might unexpectedly turn up in the future for the region and especially for these two countries? Thank you.
Okay. First and foremost, we had the Easter Sunday terror attacks. That was not because there was no law. There was a law. It was not enforced. if the penal code had been applied by the police, we could have stopped that. So it's not a question about the legal provisions that's going to keep a society safe. A society is going to be kept safe with its commitment to the rule of law, with its commitment to democracy, and with its commitment to human rights. That's how you're going to keep people being committed to being committed to that society. So if you look at terrorism and insurgency and everything, the Sri Lankan history is bathed in blood. But if you look at all that bloodshed, there is something underlying reason that's pegged in rule of law, human rights, or democracy, and we have failed in that. So fundamentally, let's get that right. Secondly, even moving on, lot of those incidences also had a political agenda, which had law enforcement also involved. And Easter Sunday, we have that, it's out there in the open. The Supreme Court has delivered its judgment about how the law enforcement failed, for reasons best known to them, in stopping those attacks. 3, then moving on, we also have the Public Security Ordinance. The Public Security Ordinance gives powers to the President to promulgate emergency regulations to deal with actual emergencies. The difference between of what is problematic with the PTA is that we are living in a permanent state of emergency. We are in a permanent state of emergency when there's actually no emergency. That's how people like Vasanta Mudalagi get arrested. Student union leaders get arrested because we have no emergency, but we have an emergency law that we'll use. But the Public Security Ordinance can be used for this. That's a short answer. Thank you.
I do agree with Mr. Hizbullah that the law that is made probably is made for good for the people, but when it is not being used, rather being abused, that is where the problem begins. I believe the problem of our subcontinent, again I'm just generalizing everything, that there has been way too much government without any governance at all. There has been too many laws, too little justice. There has been too many public servants without any public service whatsoever. And of course, too many controls and too little of welfare. So all these things coupled together, and when you have these political parties having this sort of law which they can abuse at their sweet will just to prolong their tenure in power, whether you have a simple law will not matter. They will abuse it this way and that way. So the law itself, if you do away with PTA, if our country is done away with the Anti-Terrorism Act, the Terrorism Acts will not stop. If anybody wants to do it, will do it. But what it will stop is that the abuse this government has been doing using this law, that will stop. And that, as a human rights lawyer, I believe should be done right now. If not yesterday, it should be done today. Thank you.
Are there any further questions?
That is, if somebody is kept in detention for a long period of time, or even for a day, and then released saying that, sorry, we had no grounds to detain you, we are sorry, you can go back, do you seek compensation for that?
There is no statutory provision or scheme for compensation, which ought to be, and that's something that we have been advocating for. Of course, our first position is that no PTA, but then even if so, there should be compensation. Then of course they have to have recourse to the normal tort, delictual, district court, the damages action. They'll have to institute an action in a court of law and establish that they have been wrongly detained or imprisoned, and then get relief. To my knowledge, I do not know anyone who has actually done that and been successful. Not in terms of the PTA. Not in terms of the PTA. Nobody has done that and been successful. Frankly, because once you're done with it, you just want to be done with it. You don't want to spend another day in a courthouse dealing with this scenario. And also there's a lot of intimidation going on. I know of people who have filed action and then suddenly said, no, I don't want to file it, I'm withdrawing and I'm leaving the country, and they've left the country.
Very interestingly, in Bangladesh, we have a case where this guy was behind the bar for about 12 years. And then they say that, fine, sorry, we didn't find anything, you can go. I filed a case that was basically, we do not have any tort action in Bangladesh. We filed a constitutional tort, that is a writ petition seeking compensation, judicial review seeking compensation for his unlawful detention and stuff, and he was awarded, although a very little amount of money, nothing to compensate for 12 years, but we took it as a sort of like a big victory, moral victory, that we have proved that the police was not right in detaining him, and police had to pay that sum of money.
We have a few cases of that. Fundamental rights actions where the Supreme Court has granted compensation. Ramzi Razik is the case that sort of comes into my mind. I had a client who contacted me and told me, I want to file an action for damages for what happened to me. He got into a bus, came, met me, went back, and then called me and said, I'm not filing a case. I said, what's the problem? He said, I'll come and tell you. And then he came and told me that on the way back, he was subject to acts of intimidation on the bus, where he feels they tried to plant some narcotics on his bag and then get him arrested for that. So those are the circumstances. So those are the challenges they continue to face. So I think if we are really going to, if we are going to be serious, it has to be some statutory scheme. It's not a case of me filing a case. There has to be some sort of commission or something that looks into it and awards a certain amount of money.
No, you see, you have the freedom of movement, fundamental right of freedom of movement, right? So when you are being detained, and after that they're saying that, okay, fine, you can go, your freedom of movement has been curtailed, your fundamental right has been curtailed. So you can, this is food for thought for the lawyers over here, that if they want to go ahead at some time with this.
Thank you. I think we should go on that line also.
I have a question because the audience are very silent. I have a question for both of you actually. Is that perhaps when we first, like Sri Lanka was one of the first countries to, draft that draconian anti-terror law, and at that time it was compared to the apartheid laws of South Africa. It was that bad. But at that time when the PTA was passed, it was not a commonly accepted perception that we need an anti-terror, broad sweeping anti-terror framework in a democratic country. In fact, so many parliamentarians spoke against the PTA at that time. They completely opposed it. But because of the 2/3 and so on, they were able to pass it. But now that's not the case. Now the common norm or the common perception amongst the legal community, amongst the judiciary, is that you need some kind of a broad sweeping, in fact, anti-terror law. And this permanent state of emergency which you were talking about, in fact, is necessary to counter acts of terror. So given that perception and given the fact that both of you come from a different school of thought, what I want to ask is, what would you say, or how would you influence the other camp, or the group of people from the other camp, which seems to be the dominant perception right now, in terms of the impact on democracy as a whole, as a country? When you have a broad sweeping anti-terror law, what does that do to a country's democracy when you have an anti-terror law like that? I would like to hear your thoughts on it. Thank you.
Okay. I'll start with a story for you. You said that when this bill was there in the parliament, there was debate about it, right? The political parties were divided. In Bangladesh, there is only one time I have seen that the parliamentarians have all come together and voted yes for the same cause. That was when their salary was being raised.
Same here.
Other than that, never. There is no agreement whatsoever between them. Now, very interestingly, every time we have an election, both the political parties, or all the political parties, comes up with the manifesto that they are going to scrap this law once they're elected. But when they're elected, very conveniently, that part of the manifesto is overlooked. Because the moment they go there, they see that this is one of the most potent tools they have, as I said, to prolong either their time in power or to harass the other opposition. And when you have that sort of ready-made weapon in your hand, you are not going to let that go that easily. So even if I try to convince the other side by saying that, see, now that I am using it against you, he is just going to say, don't worry, when I am going to be there, I will definitely use it threefold on you. So they are never not going to do this. The problem again is that the capacity to raise a problem for every solution is more widespread than the capacity to offer a solution for every problem. The political parties, they will always prefer to confront each other rather than confront the problem that comes against the nation together. They will never do that. So that is where I believe that unless there is political goodwill from all the parties, or you have a non-political government like ours right now, that is the only time you can do it. Otherwise, the political parties will never let this sort of weapon go. Thank you.
I mean, you're right, Swastika. Even when I read the minister presenting the PTA, sounded apologetic. When he presented in the initial debate, parliamentary debate, when he presented it, I remember him saying, "Well, it's a bad law, but it's only for a year." So that was the mood at that time. There was no bravado, and there was no or some sort of. They were not speaking of it that this is some great good we are doing for the country. They were saying, well, it's a necessary evil. That was the tone, even from the government, at least that particular minister who was advocating for it. Since then, unfortunately, so much has happened. We have had 9/11 and then Easter Sunday, and so much of violence. Society has seen so much of violence that people have come to sort of think that we'll be unsafe if we don't have a law like this. But I think that's where I think lawyers and activists and social and media need to play an important role in drawing and sort of giving out examples as to how these laws are actually used. And Aragali, I must say, at least gave us some opportunity in showing how the Aragalia, that the uprising that we saw in Sri Lanka, was actually based on economic rights, economic issues. And then we looked at the economic issues. Those bad decisions had been made by governments that had massively used draconian, these PTA laws. And why were they using? Don't talk about us when we do these stupid decisions. So that connection, that how these laws are used to make life bad for all of us, even if you're not the one who's arrested, it affects all of us in some form or another, I think might be a way forward to sort of get more people on board on this, even if they don't join us on a human rights issue, join us on a bread and butter issue.
Thank you so much. The topic today was the tension, security state versus human rights. Oh, sorry. Sorry, I'm so
Sorry, Swastika. It's just two questions very quickly to both Anik and Hijaz. Thank you very, very much. It's really about the culture of impunity that clearly exists, I think, across the world, but yeah, even here. And so the question to you, Anik, is about, in terms of the crossfire killings, I mean, there were thousands that you mentioned back in Bangladesh and enforced disappearances. Since you've become the Attorney General, thank you for all the good work that you've done in terms of repealing all those laws, has there been any prosecutions for those alleged perpetrators of these very serious human rights violations and obviously crimes? And then the question to you, Hijaz, is similar. I appreciate there probably hasn't been any prosecutions in relation to unlawful arrest or detention under the PTA, but have you thought about it in your specific case, given that you were in detention, arbitrary detention, for 22 months? Have you ever thought of challenging, in terms of, obviously now it's too late for habeas corpus, but for sure to actually bring those perpetrators to justice? And I only ask because of the ongoing intimidation and harassment and surveillance that is clearly taking place here in Sri Lanka. Thank you.
Very interestingly, yes, in both cases. When it comes to the enforced disappearances, the mastermind of that he started, there is a very interesting place we call it Ainaghar, the House of Mirrors. That is where the people who were kidnapped by the law enforcing agencies and kept, those were basically some 6 feet by 4 foot room without any windows in the basement and all that stuff. We have found those as well. And the masterminds have been identified, and he is right now being prosecuted. We are prosecuting him for the enforced disappearances. And as to the crossfire killing, not all of them could be done because it started, as I said, it's not only from last few years, it's from 2009 and stuff. But certain police officers, we have this elite force called Rapid Action Battalion. We have started prosecuting those who we have found. Especially, this is very sad that in Cox's Bazar, one of the politicians were taken, but the police could not realize that he had his cell phone in his pocket. So this guy, before his death, called his home and his daughter picked the phone up. And everything is recording that the daughter is saying, "Father, what is happening to you?" And the father says, please don't shoot. I have done nothing. You have got the wrong guy and all this. And the police is saying, the officer in charge is ordering that tie him up, kill him, and then take this bag of cement and throw him into the ocean. And all of these are there in document, and these are being prosecuted that we could pinpoint that this is the guy who has done it and not. We are in the process of pointing out and finding out that. Because I told you that this has been going on for quite a long period of time, so it's rather difficult for us to pinpoint the investigation after all these years, but the recent ones, yes, we are definitely prosecuting them. Thank you.
Thank you for putting me on the spot. I have filed a fundamental rights application, which is pending before the Supreme Court. With regard to filing a damages claim, well, I say I'm not going to do anything, just let me go, but worried about the repercussions, if at all. But certainly it's something that I'm contemplating. But if anybody asks me, I say, no, I'm not going to file anything, just let me be, and let me be in peace. I'm not going to do anything to you guys. But, and this is a reality, is the fact that despite being an attorney at law, despite all the resources at my disposal, and with all the lawyers and everything that I have, even I don't feel safe. Even I don't feel safe. So that controls everything, and that when I say I don't feel safe, not only about myself but also members of my family. It's members of my family have been stopped in, not just my immediate family, extended family have been stopped at airports, questioned, arrested, kept in custody, and asked questioned about your relationship to so and so, blah 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 blah. So there are a lot of things that I need to take into, so there are a lot of things that a detainee needs to take into consideration before they make those decisions, and that's a reality that I can see for myself.
Thank you to both the panelists. The topic was the security state, the tensions between the security state versus human rights of individuals. But I think the actual question is the security state versus the democratic state. And if we are trying to create a state of people and citizens instead of a state of suspects, I think we need to rethink our entire notion, our entire understanding of anti-terror laws, anti-terror framework, and this whole idea of terrorism. I think we all have to, as lawyers, as legal professionals, we have to think of it. So thank you so much, Mr. Haq, and thank you so much, Mr. Isbullah, for coming and giving us so much personal as well as professional insight into your experiences in dealing with anti-terror legislations in both Bangladesh as well as Sri Lanka. Thank you so much.
Thank you.
Well, Sri Lanka and Bangladesh, both neighboring countries, have faced critical situations and severe injustice because of these anti-terror laws. But as lawyers, the change agents of the society, we can play a crucial role, and especially in defending the victims of these draconian laws. So I must thank once again to Barrister Anik Haq and Mr. Hijaz Hisbullah for sharing their ideas and perspectives on this topic. On that note, we will now take a short break. Please be back by 4 p.m. and this will be a tea break, and I will ask all of you also to gather in the hall that we had our lunch.
The Supreme Court of India and founder of the Human Rights Law Network, and Mr. Nuwan Bopage, attorney at law and human rights activist, Sri Lanka. The session will be moderated by Ms. Sara Arumugam, attorney at law, Sri Lanka, and now I hand over this session to the moderator.
Good afternoon, colleagues and friends. Welcome to the panel 3 of today's Human Rights Workshop, organized by the Human Rights Committee of Bar Association of Sri Lanka. This panel is titled Lawyers at the Frontline, Defending Rights During People's Movements. I hope everyone agrees that this is a very timely conversation across South Asia, especially in Sri Lanka, Bangladesh, Nepal, and even in India. At such times, lawyers step into a critical role of protecting liberties and securing the release of unlawful detained protesters, and holding authorities accountable. But defending people's movements also comes with enormous challenges, from personal risks to institutional pressures. So today, we will reflect on these realities, and we have well-experienced, eminent panelists with us today. It's my honor to introduce them. We have two panelists with us today joining from India and from Sri Lanka. Let me give a brief introduction to both of them. Mr. Colin Gonsalves, Senior Advocate of the Supreme Court of India. He is a founder of Human Rights Law Network, a pioneering organization in public interest litigation. Over more than 3 decades, he has specialized in human rights, labor law, and constitutional litigation, securing landmark judgments on protest rights, custodial torture, government accountability, and economic, social, and cultural rights. Widely regarded as one of India's foremost public interest lawyers, he has argued several precedent-setting cases that advance protections for marginalized and vulnerable groups. In recognition of his tireless advocacy, he was awarded the 2017 Right Livelihood Award for his innovative use of law to secure fundamental rights. Next, we have Mr. Nuwan Bopage, attorney at law. He's no stranger to us, a human rights activist in Sri Lanka, a frontline defender of democratic freedoms in Sri Lanka, especially during the Aragalaya movement, and also in any other civic movements we have seen him. He has represented protesters, students, and trade unions facing legal actions. So we are honored to have both of you, and thank you so much for agreeing to join with our discussion today. We have 1 hour together, so we will start with Mr. Colin Gonsalves, and we will next go with Nuwan. I think you have a presentation, right? So until we get the presentation on screen, I think you may cover on the recent uprisings that happened in India, especially with the Anti-Citizenship Amendment Act, protest happened in 2019 and 20, the farmers' protest between 2020 and 21. I think that is one of the longest running protest movements in Indian history. I'm sure that you must have been part of that. And most recently, during protest against new criminal laws in 2024 and 25. So we have a lot to learn from you, sir. Against this backdrop, Mr. Gonsalves have spent decades at forefront of public interest litigation in India. So we are ready to hear from you.
Thank you. Things have been so hard for us in India for such a long time. It's been like a storm, thunder and lightning, dark clouds, and so on. I came to Sri Lanka before the storm began, 10 years ago, before Modi came to India, to power, 10, 11 years ago. And I had an optimistic story to tell. I have an optimistic story to tell today. But it was a different kind of optimism. We're in the courts, we are winning this case, we are winning that case, and so on. And the right to food case, which was a historic case, had come up in the Supreme Court. And we had won case after case. That was 10, 11 years ago. And now we've come to a terrible turn in our fortunes. But for a human rights activist, it's not a bad thing. For a human rights activist to face adversity, jail terms, torture, detention, freezing of your bank accounts, all these things are normal. And I tell my colleagues, some of my colleagues are, little advanced in their age, like I am. And some of them say, we want to retire and, we don't want to carry on anymore in this rotten system. And I tell them this is the finest time to live. This is the finest period for a human rights activist to live through. Because all your life you live to fight against oppression. David versus Goliath, right? Goliath was a giant and David had a slingshot. He had a catapult. And he knocked the mighty Goliath down. All our lives and all your lives as students of law, as young lawyers, as human rights activists, all of you will live your lives a single individual against a mighty giant, and you will knock him down. So that's the joy of life that we look forward to. That's what our lives have been dedicated for. I thank you for calling me. I've been so invigorated by the discussions today and by the kind of speeches made. And from Judge Saab to all the speakers from Pakistan, Sri Lanka, Bangladesh, my dear friends, whom I met many years ago when they were in jail. Can you imagine? The activists of Adhikar were in jail. And when the uprising took place, I called him and I said, "Where are you now?" And he says, "I'm a cabinet minister now." Can you imagine? So I'm very hopeful and I'm very positive. I've always been optimistic, foolishly optimistic perhaps. But it is a very important period that we are living through. And I think it is a period of the decline of this kind of state terrorism. We are talking about terrorism, and I always speak openly in my country. I invite the wrath of the people in power. When I talk about terrorism legislation, I say the biggest terrorist in this country, India, is the police force. The biggest terrorists in the country are the ministers who are sitting in the cabinet. It is they who spread terror throughout the country. So don't worry, don't feel diffident, don't go on the back foot, don't feel, defensive and things like that. Fight on. I have limited time, and this person to my left has been threatening me a little bit, so I must go quickly as I can. Joker. Many years ago, 10 years ago, we started an initiative called the Global South, Human Rights and the Global South, because we felt that the jurisprudence of the Global South is ignored. And I managed to get money in those days before Mr. Modi froze all my bank accounts. I managed to get some money. And I went to Afghanistan, Nepal, Bangladesh, Pakistan, Sri Lanka. And I met with activists and lawyers here. We did 2 rounds of meetings. And then we had 2 rounds of meetings in JNU, Jawaharlal Nehru University, Delhi, where the lawyers and activists came there. And we wanted to spread out after that. And this is a little hint as to what we can do really with our friends from Bangladesh and Sri Lanka and others. We have to go to Latin America. We have to go to South America, because South America is another beacon of light. If you want to know how to go ahead on human rights, if you want to understand what kind of initiatives you can take, South America is another beacon of light. Positive energy from South America. Particularly with how human rights lawyers can fight against regimes and military regimes, like in Spain, France, and so on. And in South America, like in Colombia and so on, how they fought against regimes, military regimes, and what kind of judgments they got. Nobody from the West, nobody from the developed countries ever looks at the Global South. And I was startled, because when I went to give an occasional lecture in Yale or Harvard or, in the UK and so on, in SOAS in the UK, I was so surprised that the professors there, when they talk of human rights, their vision is so blinkered as compared to us from the Global South. So narrow. So you never think of, a leading continent of human rights litigation and activism to bring them into your discourse. And then you go to Africa and you find black African lawyers doing extraordinary work in Africa. So if you have an idea and you have the resources to actually do these meetings, and we can get many to collaborate in Africa, South America, South Asia, we are there. India, we are there. But these are the two countries left out. We can do a really good initiative on globalization, human rights, and the law in the global South. Now, let me start. The first point I want to make is about the Indian judiciary. One of the finest in the world. Our judgments are stunning, absolutely stunning. Our judges used to be extraordinary. But then Mr. Modi came. 11 years of systematic dismantling of a beautiful superstructure of law enforcement. And he filled the courts with people who are more loyal to him than to the Constitution. To give you an example, we had a judge in the Supreme Court who, while he was a judge in the Supreme Court, made the statement that Mr. Modi is my God. Can you imagine? And so everybody listened and everybody commented and some laughed and some criticized. But it's a terrible thing to say, because it means once a judge says that the Prime Minister of the country is his God, it means you are no longer entitled. You are no longer qualified really to be a judge, because independence of the judiciary is the main thing about a judge. And the sad thing about it was the Chief Justices over the last 5, 6, 7 years, 8 years, who brought down the structure that they themselves had climbed up to the pinnacle. It was the Chief Justices who systematically dismantled our judicial independence and our judicial courage and the greatness of the Indian judiciary. And that's the truth about India today, because judges have come in who are obliged to a particular government, a particular ideology, and they are not so concerned about what the Constitution says. And if there's something that the party says, and there's something that the Constitution requires, they'll choose the party over the Constitution. So much so that about, I think, 3 months ago, a judge of the Supreme Court who retired normally gets a party, a farewell party from the bar. And for the first time, there was a boycott of that judge. Nobody went for the party, nobody organized the party, and that judge retired without the usual farewell. A very symbolic gesture, although I think we should have had much more to say about that judge. Look at the situation in the country. I want to say a few points about that. There are so many lawyers in jail, so many right to information activists in jail, so many social workers in jail, so many tribal activists in jail, so many Dalit activists in jail, so many cartoonists in jail under sedition law. Can you imagine that you drew a cartoon of the Prime Minister or something and so on, and you're taken under sedition law and put in jail for so many years? And I particularly want to mention today Surendra Gadling from Nagpur. If you can remember these names, please, because these are the new generation freedom fighters. A day will come, like we put up our portraits of our freedom fighters who fought against the British. A day will come when these portraits will be put up on the walls of the Bar Association. Gadling, a lawyer from Nagpur, he served tribal areas diligently, came from a poor family, in jail 5 years. Charges not framed under UAPA charges. Sudha Bharadwaj, that name you would have heard, from Chhattisgarh, spent her life in a small, modest office in Chhattisgarh, fighting often without money, but fighting cases on behalf of the tribals of Chhattisgarh. Why? Because somebody found a letter which it was said was Sudha's letter, not taken from her computer, not seized from her house, not seized from her person, not written by her, not signed by her. That letter, on the basis of that completely pseudo letter, she spent 5 years in jail. Stan Swami, 82 years old, Christian Jesuit priest, simple man, never did violence in his life, suffering from Parkinson's disease. He was shaking to it. He needed a sipper to take water, sipper. And the government said, no, you're in a terrorist prosecution, no sipper for you. Died at 82 in jail. And then Sai Baba, disabled person, severely disabled, again a professor, never done violence in his life, but a strong proponent of speech against the government. What was it common to all these people? What was it that they did which made them liable to be prosecuted under terrorism law? One thing which they did, which they admitted doing, they spoke out bravely against the government. They said your government is fascist. They said your government is a dictator. Your government is like Modi, like Hitler. All that they said. Any evidence against them? That they used a gun or, some bomb? No evidence against them of violence. And so, my dear friends, this is the lesson we have to learn from the regimes we are getting into. Of course, Bangladesh and Nepal may come out of it. What they hate most, the government, is not your ability to do warfare or, violence. They know the power of their military. They know the power of their police. We are little mosquitoes in front of them. They just do this and we are dead. Speech is what they can't stand. That young people will stand up and criticize the government knowledgeably, criticize the government fervently. That is what they cannot stand. And we are facing this onslaught in the guise of the fight against terrorism is only a fight against free speech. And everything else that follows, this attempt to get this digital media regulated, don't go anywhere near that. You might think there are some positive points of criminal defamation. Never allow. Be very black and white on this issue. Somebody tells you digital media has to be controlled, even though digital media may occasionally be totally out of control. Suffer that. Suffer that and find ways of controlling that, but never allow regulation of free speech. Excess, outright excess, pretty bad stuff, I know. But be very careful. Never allow regulation of free speech. And Khalid, the most famous of our revolutionaries in jail, 6 years in jail, charges not framed. Charges not framed. Can you imagine even the first step of framing charges, not that in Khalid's case? What did he do? According to the prosecution case, he used provocative speech. For God's sake, our right to speech case law in India is rich. You can say anything you want as long as you don't incite violence. You can say anything. Khalistan Zindabad, we want a separate homeland for Sikhs. Supreme Court said, all right. Nothing really happened. Nobody fired a gun or something for independence. That's all right. Azadi, freedom. It's all right. What's the problem with Azadi and so on and so forth? Now, I want to tell you about some of the dangerous things that are happening, which may come across the continent as well, the subcontinent. Electronic voting machines will take away your democracy. And in India, that is starting on a very large scale, where the government can interfere with your voting machines and give you a result totally opposite to what the voter had voted for. Totally opposite. We have already had 2 Chief Justices who rubbished the petitions who came before the court. Petitions were filed saying, sir, anybody in India, if you advertise in the newspaper for any 18-year-old to hack into an EVM machine, I tell you there'll be 50,000 people applying. And our hackers in India are quite capable of hacking into the Pentagon computers, you know? And the judges said, no, it's not capable, not capable. But the EVM machine will be the turning point. And if that happens in India, there'll be really outrage against the government for that. We have to go back. We have to go back to the paper ballot. We must. It's there in America. It's there in the whole of Europe. There is no reason why we should go into a mechanism like the electronic voting. Surveillance. In the last 10 years, India has become the country with the highest rate of surveillance in the world. You can't believe this. Highest rate and no control at all. And to add to that, unlike America and Europe and so on, you have private parties doing surveillance across the country. I don't want to mention names of industrialists, but very prominent industrial houses all do surveillance. They do surveillance of their political opponents. They do surveillance of human rights activists. And some time ago, when the Delhi High Court had a 50 years celebration of the Delhi High Court, the Chief Minister, in front of all the judges of the Supreme Court, the Chief Minister in his speech said, "What is this I am hearing? The judges are telling me that all their phones have been placed under surveillance." And the Home Minister was there, the Prime Minister was there, everybody was there, and everybody's looking at each other, very embarrassed, because the Chief Minister said what everybody knows. All judges' communications are under surveillance. All human rights activists' communications on their phone are under surveillance. You may think WhatsApp is encrypted. There's no such thing as security. The Israelis play a very big role in India, very big role. And the Israelis are top of the notch when it comes to surveillance. You may think your, what is it called, signal is safe. Nothing is safe, and so on. So surveillance is of a very high level. 20,000 NGOs, can you imagine, closed down by the government, including mine, the Human Rights Law Network. Otherwise, I would have come to Sri Lanka more often. But no money now. No money for this. 20,000 NGOs cancelled. So I go to court. They check my accounts. They check my personal accounts. How did you buy your house? Everything. They go to my bank. They get all the data. They find nothing. So then in the High Court, they say the reason why we closed Mr. Gonsalves down was he's using foreign money to discredit our government. So when it came before the court, I told the judge, sir, of all these charges of money misappropriation and all that, you can see it's clear now. But I admit to one charge. I admit that my public interest litigation is reported in the media and the orders of the court discredit the government. That is perfectly correct. If that's the issue you have to decide, please decide whether foreign money can be used to do human rights work which ultimately discredits the government. I think it's perfectly right. You have to decide now, and that case is going on in court. Muslims, I want to tell you a little. I think the Muslims of our country have faced real terror, unimaginable terror, lynching. Who takes a Muslim and ties him up to a tree and hangs him from a tree in this day and age? And for what? He was caught eating beef. Whatever. Can you imagine? All those lynching cases, not a single successful prosecution. Violence, all kinds of violence. You're a Muslim, you stay in a slum, your home will be demolished. Demolition of slums based on whether you're a Muslim or a non-Muslim. Non-Muslims will be left. The Muslim houses will be marked like they did to the Jews. Will be marking on their doors, and then the bulldozer will come and break the houses of Muslims. Hate speech, including hate speech by our Prime Minister. All kinds of rubbish. How did the Delhi riots start? The Delhi riot started. Khalid is in jail. And if you've read the newspaper, probably you know. Khalid is in jail, and the accusation against him is that he conspired to start the Delhi riots. Delhi riots started, and I have a case in the court, pending in court, which no judge is wanting to touch. A cabinet minister and a member of parliament was at a meeting. He called the video cameras in front of him, and then he started slogan shouting, "Desh ke gaddaro ko goli maro salo ko." To the anti-terrorists, to the anti-nationalists of India, shoot them down. Repeat after me, they repeated. Repeat after me. And that's how the Delhi riots started. And that slogan went viral right across the country. Desh ke gaddaro ko goli maro salo. So who started the riots? A cabinet minister of Mr. Modi, a member of parliament, and some other MLAs and so on, members of the Legislative Assembly. And the Jamia violence, where young students of Jamia, wanting to protest against this, what is called the NRC, basically identifying Muslims as foreigners and then having them evicted from the country. 19 lakh foreigners, can you imagine? 19 lakh. They've stayed in India for what, 30 years? They've got land, they've got shops, they've got government jobs, some are in the police, and you've declared them all to be foreigners. The UN resolution against statelessness says no country shall ever create statelessness, which means that you will never say that a person who's accepted to be a citizen is a non-citizen if that person will never be accepted by any other country. So you told these 19 lakhs you're not a citizen of India. Bangladesh says, and perhaps justifiably so, they're not our citizen, and no country in the world is willing to take them. That is, so 19 lakhs people are now waiting to be deported, and they have already spent 10 years in detention centers. What to say of India? Then the Rohingya thing happened, where the government began picking up Rohingya refugees. Refugees in our constitution are protected by law. Article 21, the right to life, is a right to life for anyone residing within the territory of India, not to citizens alone, protected by law. We have a judgment of our Supreme Court. And yet the government picked them up one night. I did a case. I said, give a stay, my lord. They're going to be sent. Judge said no. Supreme Court said no. We'll hear the matter later. That night they picked them up. Tortured them. Picked them up. Took them by airplane to the Andaman Islands. In the Andaman Islands, they put them on small boats. There were children, women and children among them. They put life jackets on them and sent them out towards Thailand. In Thailand, they landed up in the war zone. And Myanmar has been found guilty by the International Commission for Jurists of committing genocide against the Rohingyas. And they were there. And the last we spoke to them was a couple of days ago. An underground group in Myanmar found them on the beach and protected them for some time. This is India for you, the land of Mahatma Gandhi, the land of non-violence, the originator of the Universal Declaration of Human Rights, where Vijay Lakshmi Pandit, the sister of Jawaharlal Nehru, signed that declaration. This is India today. You can imagine why I say we are living in a country of perpetual dark clouds and lightning and storms and so on, all the time. Now, I want to tell you what they are aiming at. Secularism is the biggest thing. They want to turn India into a Hindu Rashtra. They give examples of Muslim countries that are Islamic by nature. And I remember reading the Bangladesh, I don't know if I'm right, you correct me if I'm right. The Bangladesh had 2 constitution bench judgments, or 1 constitution bench judgment, saying that it might be an Islamic correct me if I'm wrong, it might be an Islamic country. The religion is Islam, maybe, but the constitution is secular. Am I right on that? My memory is okay. So, yeah. I said, what are you talking about? Look at the constitution of Bangladesh. What are you saying? That you say, we want a Hindu Rashtra because Islamic countries have. So there's a judgment standing in their way, which is the 11-judge bench judgment in Keshavananda Bharati. Secularism is the backbone of the Constitution. Secularism is the spine of the Constitution. And after that, you have a 5-judge bench in S.R. Bomai. Stunning judgment, which the right wing don't know how to get over, because they must have enough judges in the Supreme Court for them to have a larger bench of 13 judges. S.R. Bomai, see the brilliance of our earlier judges. State has no religion. Powerful. State has no religion. The state stands apart from religion. Beautiful, isn't it? It's poetic almost. The state stands apart from religion. And that's what stands in the way as far as the judiciary is concerned. They don't know what to do because they haven't got enough of judges packed in the Supreme Court who will reverse Keshavananda Bharati's judgment. Now, on independence of the judiciary, to summarize in a few words, our judges have become supine, surrendered, because it's been 10 years of Modi's rule. And I think there is a formula in this. The stronger the executive, the more dictatorial an executive, the more violent an executive. And if the executive can wreak vengeance on judges and victimize the judges, so on, the more supine the judiciary becomes. So we have 30-40% maybe still good, fighting back from inside the judiciary. But we are very different from earlier, and I can't boast as I used to boast earlier about the wonderful judgments of our court. Then, the method used to intimidate judges, apart from, getting into your mobile phone of your sons and daughters and your family and your wife, taping what they're saying and talking and so on, which is a deadly thing to do, really, is the supersession of judges. So if you see now, the next 3 or 4 Chief Justices have been taken from the bottom of the seniority list, or halfway of the seniority list. You pick a person from across the country from some high court who's low down in the seniority list and bring him to Delhi straight away. Can you imagine the judges who are there? Say he superseded 5 judges, 10 judges, how they would feel after giving their life of service to the country and the judiciary to have a junior judge taken and put there. Supersession. And the second way of punishment is to send him to a high court. Send him or her to a high court where there is no work at all. The High Court of Sikkim has few cases. The High Court of Meghalaya has few cases. So from a very big High Court, in order to push you down a bit, you'll be sent to a High Court where there's very little work. Now, a few things, and I'm finishing quickly. Learning from each other. That's a beautiful phrase to use for your conference. Learning from each other. And if we really follow this, and if I think my Sri Lankan friends can take the lead, along with our friends from Bangladesh, because you all are not under such attack as we are in India, take the lead. There are many in Latin America who will join your network. There'll be hundreds of lawyers, and I can help in this because I've been in touch, I've spoken to people. From Latin America, you'll get hundreds of lawyers, fight for human rights, like you have Doctors Without Borders, right? Justice without borders, human rights without borders. You'll get hundreds of lawyers from Latin America joining. You'll get hundreds of people from Africa joining. The ground has been set, in a sense. The seeds have been sown. All you have to do is, if you team up and we contact people, build the initiative, not just to learn, but it's a combat unit of lawyers. It's not just a learning unit, it's a combat unit to fight against justice everywhere. Terrorism legislation has been studied across the world, in the developed world as well. And they can contribute enormously to the discussions you're having in Sri Lanka and elsewhere in Bangladesh on terrorism legislation and why it should be done. About Nepal, I want to say something, sir. I'm finishing now. You see, sir, at the end of your speech, you spoke of 2 cases that you did. Your court did, sir. The marital rape case and the right to marry. And when I read those judgments, and I used the argument in court, sir, when we were arguing these cases, people, it's this power thing, this American Western power thing. We're a big country, we have a lot of money, so we know. And Nepal is a small country with modest resources. What a judiciary. What a judiciary. We had this case in the Supreme Court on marital rape. Can you imagine anything more simple? Using force against a woman, against her will, and having sex, rape. Exclusion clause, but not applicable if it's the husband who's doing the rape. Can you imagine how banal and how stupid we can be in drafting a law like this? And this goes back hundreds of years to Lord Hume, I think. Lord Hale, who said, when a woman marries a man, now I'm using the English language thing, she doth give herself up to him, from which she can never recant. Can you imagine? When a woman marries a man, this is the principle that lasted for hundreds of years, and a principle which is used in India today. She gives herself to him, from which position she cannot turn away. Nepal, I saw the judgment, sir, of Nepal. Nepal has a very, I think, I've seen not many, but I've seen a nice way of writing. It's not like the Indian way. The Indian way on this matter will write 200 pages. 200 pages and 50, 60 pages will be direct quotations. When a judge dictates, he'll take a book and say, so from here to there, copy. So 50 pages done. Nepal doesn't seem to do that. Nepal comes straight to the point and says this. And in India, they use the argument that, you see, sir, all this marital rape and all this is a Western concept. In India, we are Hindus, sir. We are religious people. We don't do marital rape. So the Nepal judgment, when I read it, sorted out that problem for me. Because the Nepal court cleverly said, and nicely said, we are a Hindu nation. We are proud of our Hinduism. No upright Hindu would ever rape his wife, and if he does it, he should be punished. They brought, I'm quoting it maybe slightly incorrectly, but they basically they took the argument. They didn't run away from the argument that a Hindu nation can't rape its women. They took the argument, but they said, it's not part of our Hinduism to have violence against our wives. Therefore, you do it, you are acting against your own religion. I was with deep apology if I'm little... because it was an argument in the Supreme Court that, sir, this is a Western notion. Then we showed the statistics. Right across the country, they did surveys. They went to Uttar Pradesh, Rajasthan, and they asked the women, they asked the men, sir, we want to ask you a simple question. When your wife doesn't want to have sex, do you still insist? Now, men are men. Men are men. Naturally. They don't understand what they're saying. They don't understand what crime they are committing. It's the largest body of crime in the country. And it showed in Uttar Pradesh 60%, Rajasthan 60%. Can you imagine? If 50% of your female married population, or take even 30%, 40%, is subjected to unwilling intercourse from their husbands so often, which is the biggest crime committed in any country? Is it murder? What is it? It's marital rape, forcing yourself on a woman against her will. And then the right to marry. We have a judge, we had a Chief Justice, Justice Chandra. I'm ending now, ma'am, I promise. Chief Justice Chandrachud, who always thought that he was, the cat's whiskers when it came to, erudite judgment writing. He led a bench. It was the most shameful day for India. And all the groups in India, the LGBTQI groups, the transgender, all of them, thought he would definitely say that this provision which says that marriage is between two persons of different sexes, is constitutionally valid. And he said, you have no right to marry. He rejected it. It was the saddest day for our for everybody actually, but also for our LGBTQI. Thank you very much, and thank you for your patience.
No, actually, I couldn't even stop you because it was so interesting, and I think you gave so much of insights, and it's really concerning. And I think, as a region, we need to take this very serious, and we can see that, we are really heading towards a security state even in Sri Lanka, because we can draw parallels from India, right?
So I can
because
take 5 minutes more to finish?
Because we have the next speaker. Okay, over to you, Nuan. You can do your presentation now.
Thank you very much. Actually, I must first of all tell I am honored to sit with Mr. Gonzalez. As I remember in 2013, just after the impeachment, the struggle against the impeachment of Chief Justice Shirani Bandaranaike, the Bar Association gave me that opportunity to attend one of the sessions held in New Delhi in 2014. I think Mr. Gonzalez, through Mr. Gonzalez NGO only, they organized that event to inculcate certain aspects about the fundamental rights violations. So I remember certain sessions that organized regarding the violations focused on Dalit community. Still, I can remember what I learned out of that session. So I think Mr. Gonzalez might not remember me that I participated because I had a lot of hair those days, unlike today. The other thing is the Indian experience. Always we read, we study Indian experience. But during last 3-4 decades, Sri Lankan experience also much different with India. However, now today mainly our topic is focused on lawyers at frontline, lawyers at the front line defending rights during the people's movement. So that is our topic today. So I think ideal Gonzalez's speech is very ideal speech regarding this topic, being a frontline activist in India. Thing is now today is one of the ideal days to discuss regarding the activism, because you all aware right now what is the most horrible fundamental rights violation in this world. We know what is happening in Gaza right now. Even today, there are around 40 ships or boats are sailing towards Gaza with a lot of frontline defenders, fundamental right activists, to break that siege in Gaza. So we are discussing these fundamental rights and activism in a day which very important as far as the world history is concerned, because I think in this century, that is the best ever human right defending activity or movement we have seen. So I take this opportunity to give my honor, express my honor to that particular campaign. So at the same time, wherever, now here there are a lot of young activists or young lawyers in Sri Lanka. Have you ever read or have you ever studied what is happening in Gaza? If you really want to be an activist, human rights defender, first of all you should have concern about these violations, because law college is there, faculty is there, they can teach us certain subjects and they can give us a degree. But nobody can give a degree for activism. It should be come from your heart, with your conscience. So what is happening in Gaza, whether you have a concern about that, 700,000 people killed, already killed. Around 500,000 people are starving, that is 22% out of their population. So that is the most horrible humanitarian crisis right now in this world. So once if your heart doesn't speaks about this, it doesn't feel that, first of all, we can't be activists, we can't be human rights defenders. That's why once Che said, if you are tremble with indignation every time an injustice committed in this world, then we are comrades. What he said. Wherever, it can be India, Bangladesh, Nepal, if there is an injustice is committed, first you should feel that. So that is the starting point of being activist. Now, I go to this slide where it says, human rights activism involves individual and group taking action to promote and protect the fundamental rights of others. So it can be as an individual or as a group, as an organization. So Mr. Gonzalez, he had an NGO. In Sri Lanka, there are a lot of NGOs. So as a group, they are trying to do something to defend fundamentals. But in Sri Lankan context, we could see a lot of individuals who are in front line to protect, safeguard the fundamental rights. Why we should protect the fundamental rights? Whereas now, intellectual property, I am using this word just to give some sort of understanding, but intellectual property law is one of the draconian laws according to me, because nobody can claim intellectual property rights to anything, because those things are evolved from the history through the sacrifices of the people. So scientists, if you are making a drug, how a company, multinational company, asking money for their intellectual property rights? From the history, how many people sacrificed their life to invent that particular drug? But one company, multinational company or some company come in and earning money out of that drug without concerning about the history. But what I am saying, I want to say, the fundamental rights also have an intellectual property right. Who? You might know Giordano Bruno. Why he sacrificed his life? He said, when all rulers saying all the planets are going around the earth, he came forward and said, no, that is wrong. All the planets are surrounded by sun. That is what he said. That is his freedom of thought. Then he was asked to reverse that particular opinion. He refused to do that. As a result of that, he was executed. Now he sacrificed, he decided to not to reverse or not to take different opinion. As a result of that, he was killed. So this is how people invented fundamental rights, freedom of thought. Then we are, day-to-day life, we are using Article 12.1, all are equal before law. In French Revolution, the French Declaration, that was contained, all are equal before law. How many people sacrificed for French Revolutions? millions of people sacrificed their life during the French Revolution. Through that only, they gave some sort of value for these fundamental rights. Socrates was executed because of his teachings, freedom of expression. He never ready to withdraw his teachings. Then he was executed. That is freedom of expression. So when we go to the world history, how many people sacrificed their life to protect fundamental rights? So we being the current generation, first of all, that should be in your mind when you go to the court, when you are arguing matters, when you want to defend certain things. That should be in your mind, because we are doing a sacred duty. We are doing a sacred duty. Struggle is also a sacred right of the people. Now we face Sri Lankan struggle 2022. You know how many lawyers came forward and defended those activists? Why? Maybe lot of lawyers, they didn't have any concern about the struggle. They are lawyers, they want to defend that. But what is the undercurrent objective? That is, the French Revolution said, struggle is a sacred right of the people. That's a part of the freedom of expression. So that should be in your mind always when you are defending fundamental right cases in court. Now, why the lawyers? Now, today we all are lawyers and judges or judges. The lawyers, once you be a lawyer, you get some sort of civil status in the society. Especially in Sri Lanka, this South Asian context, that is there. So that particular civil status gives some sort of power you to defend others. All the others are recognized. Once you be a lawyer, all others are recognized you as a leader or protector. So using that civil status, we get a lot of chances to defend people and go to the front line of most of the struggles and fights. So why we have been given such power in the society? Because advocate and lobby is one of the most important things when you want to inculcate something in the society or teach something. So that is inherent part of our practice. Lawyers, we always doing in front of courts what? Advocate and lobbying. That is there as a part of our profession. Then provide assistance, you all can understand. Educate and raise awareness, that is also part of our profession. And the other thing is the most important, direct actions. Direct actions. So I think we are still lack of these direct actions. But being lawyers, we always get that opportunity, go to the front line of most of the struggles and fight and give leadership to them. So I will quickly go to few examples. Now this is a campaign in Iran for female lawyers in Iran. I think you might know Mahsa Amini's incident. She was killed because of she was not wearing a hijab. So a lot of lawyers in Iran, especially female lawyers, they came forward and there is a campaign for that rights. So the lawyers were given that recognition in that society, even though it's a religious society, being lawyers, they got some sort of protection. And campaign for independence and judiciary in Pakistan, March 2007, a lot of lawyers came forward. He's an army leader, army dictator, Pervez Musharraf. When he suspended their chief justice, the lawyers only came forward and fight. So they use that civil power, that civil status to mobilize the people, to fight, to struggle. So that advantage always there with lawyers. And the Sri Lankan impeachment, I think Lakshani is here, lot of familiar faces here. We were fought together during that 2 years period of time, not because of Justice Tirani Bandaranaike. We fought for independence of judiciary. Now, whoever in the Supreme Court, judges, giving due respect to them, They should be aware of this. We fought. So once I remember this, when I was arguing Kalukale case, recently delivered judgment, at the leave stage, one Supreme Court judge asked, it was regarding the protest. They blocked the road, the farmers blocked the road, and that judge asked me, how you can block the roads? Vehicles are moving, people are moving. This is a terrible incident. I am not willing to give leave to this particular case. Then my submission was, dear sir, when your independence of judiciary was facing a challenge in 2012, we also did the same thing as lawyers. We blocked the road of the Halsroff. We didn't allow vehicle to move. As a result of that, we were able to protect your rights, independence of judiciary. Finally, the other two judges granted leave. However, during the impeachment struggle, how many lawyers came forward and fought against that? It was a very difficult era, like Modi era in Sri Lanka. Nationalism is the main decisive part of their ruling, nationalism. Using that, they interfere with judiciary, interfere with all the other sectors, and white wine culture was there. Amidst all these things, we were able to fight as lawyers together. That civil power was with us. Then 2022, recent Aragale. You all can remember. Here, Swastika and others also there. Sometimes when they arrested activists, they were produced before magistrate court in the midnight. So a lot of lawyers, without having any concern about their security and transport, money, nothing, they came to judge's chamber and made submission asking bail. At the same time, when a group of mobs were coming to attack the activists of the Aragalaya, the lawyers, they were hand in hand, they were in the front of the Aragalaya to protect the Aragalaya people. So that's how the lawyers participated and they came forward as frontline defenders during the Aragalaya. So we know about these incidents. So the other thing is, now as individuals, we can do certain things. Now, Mr. Gonzalez talked about secularism. Who brought this word, this concept to the Indian Constitution? This is B.R. Ambedkar. He's a lawyer. He was hailing from a Dalit background. And when he was a member, the chairman of the Constitutional Drafting Committee, then he brought this concept to the Constitution in India. Can you imagine if we propose to convert our Constitution to a secular Constitution? I think this so-called left government, in their manifesto, they were so reluctant to put this as one of their promises. They didn't do that. Why? So it is, now, in Sri Lankan Constitution, we know the prominence has been given to one religion. So we all might have a different idea, but that word itself, violation of fundamental rights. The state should be secular. State should not have any religion or race. It should be part of the Constitution. Ambedkar, being a human rights activist, lawyer, he fought for that. Then he was successful. Practically what is happening in India is something different thing. But including it as a part of their constitution is a revolutionary concept. And most of us, I think, refer his cases, MC Mehta. Lot of cases, he is the petitioner in India. He's a human rights activist, like Mr. Gonzalez. So there are plenty of cases, landmark judgments we refer. So being a lawyer, he used his civil status and knowledge in order to protect fundamental rights. Then you all know Adjoa Ayotora in US. She is also an activist, especially regarding LGBTQ rights and other rights. I'll quickly go there. Then you know the Nelson Mandela. In South African apartheid, subsequently he became the president, but he's the one who formed first black law firm in South Africa. Can you imagine in 1960s when you forming a black firm in South Africa? Definitely it endangers your life, but he did that. He's a lawyer. He used that his civil status in order to protect fundamental rights. Other two characters, actually Fidel Castro, he was not a practitioner, but he got a law degree. So once he said, his legal knowledge actually sharpened, and it was, when he was taking decisions, it was so helpful him, his legal knowledge and his legal background. Lenin as well, he was a lawyer, he was a practitioner. So he was very sharp in taking decisions. In 1970 in February, he had a good opportunity to take over the power. He didn't take that. He waited till October. Why? He had that rational thinking how to handle the situations. He got that ability through their legal knowledge. So what I want to say, being a lawyer, we always have that opportunity. What is that? First of all, naturally, you get opportunity to lead people, people recognize because of your civil status. Secondly, we always advocate in others. Through that, we get some sort of rational thinking. We can take very prompt decisions. When we are on feet in court, immediately we have to change our mindset based on the questions that posing us by the judges. So that ability is part of our profession. Using that, we can easily lead the society. We can easily be activists for the betterment of the society. So therefore, being individuals, as individuals, we can do certain things for the betterment of the people and to protect the fundamental rights. Furthermore, we know a lot of NGOs here because in 1993, for Vienna conference, around 800 NGOs participated as frontline defenders, fundamental right defenders. Right now, there are a lot of NGOs, certain criticism there because when I was going to India for some left conference, certain left parties in India, they are of the view these NGOs are part of the imperial agenda because most of the funds are coming from global north, USA. USAID also, I think, sometimes they funded by association as well. So with that, their imperial agendas are always within the NGOs. That is their criticism. So to a certain extent, that is correct. However, for the moment, we can undermine certain NGOs still fighting for the betterment to protect the fundamental rights. In Sri Lankan context, we know there are few NGOs, especially to protect the environment. There are filing cases, using their funds, actually they are giving legal aid to the people. So like Mr. Gonzalez in India. So as a group, as an organization, you can defend fundamental rights. So most of these NGOs are concerned, I think a lot of lawyers are actively participating in these NGOs and doing plenty of work for the betterment of the society. So basically, as individuals, you can be in front of the struggles, you can be in the front of the movements. At the same time, as group, as NGOs, you can do that. Finally, what I want to summarize my presentation, what I want to tell, in Sri Lankan context, recently, you know, now there's a discussion regarding new terrorism law. Instead of prevention of terrorism law, now government is planning to bring new law regarding the terrorism. So we know how this prevention of terrorism law was affected the society. I think Hijaz was here. So I actively participated in Hijaz case. During the COVID season only he was arrested, framing false charges under PTA, Prevention of Terrorism Law. So actually, to get the signature of certain petitions, I was compelled to jump over walls because the entire country was shut down because of COVID, because of the COVID. So if you want to defend, if you want to be an activist, you will be ready to face any consequences out of that. So that is one of the challenges facing by the activists. You know, during the 1988-89 period, Vijayadasa Jayarajchi, one of the prominent best lawyers in this country, he was killed. He was killed. Why? Because of his activism. He appeared for a lot of people there, the vulnerable groups, at the same time who were affected due to the 1988-89 incidents. As a result of that, he was killed. So if you want to really be an activist defender, you might have to face these kind of incidents. So during the 2022 Aragala, including me, few lawyers were arrested. We were attacked by the government. So we should face that. So Hijaz incident, so he also faced this kind of incident because of he's a lawyer, he's an active lawyer. So at the same time, I can remember the Chunnakam case, which I handled. So in Chunnakam case, the clients came, met me, gave instructions. Just before a day filing that case, they were disappeared. No instructions from clients. No instruction from client. Then, within 1 month we should file fundamental right case. Then somehow I find one of my friend who is a member of environmental association, then I file the case. So later it has become one of the landmark cases, but those are the challenges we face. What happened, that company, finally I got to know that company bribed these clients, the villagers in Jaffna. So the halfway through the case, they wanted to bribe lawyers as well. So those are the challenges we have. They use money. India, I think this is happening regularly. This is happening regularly. So these are the challenges that we face. So therefore, if you really want to be activist, if you really want to be in the front line, that should become bottom of your heart. Nobody can inculcate in your mindset. So it should become bottom of your heart. So finally, in a nutshell, what I want to say, in Sri Lankan context, Bar Association played major role during the Aragale, and we have a very progressive bar. So we should always use that mentality of the lawyers in order to protect the fundamental rights. In future, there will be more challenges because now we are under IMF plan. IMF agenda always detrimental to the people. That is the nature of that. So they might insist Sri Lankan government to bring more draconian laws. At the same time, there will be a lot of other austerity measures in future. So people will get more affected. As a result of that, people will not be able to get the access to law very easily. So in a situation like that, bar has to play a big role in our society. So we should, basically, as lawyers, we should get ready for these challenges in future. I believe this kind of programs, this kind of workshop will be helpful to build that kind of straightforward and brave young lawyers in order to face that challenge in future. Thank you.
Thank you, Nuwan. Thank you so much for sharing those insights. And I think both of y'all have so much of personal experience. So you shared your lived experience. What we really see is that both countries are really going towards facing a lot of human rights restrictions, and also we see that more and more restrictive laws are coming up. So as the region, would you both comment on how we can strengthen this solidarity and also like, reaching out to new partners, like especially the Global South, the Latin American countries. I think they're also, very strong in strengthening democracy and fighting for people's rights. So in that context, how do you think that, we should move forward, especially working with the regional bars, and how can we move forward? If you can just give some ideas, maybe that will be helpful for us to kind of envision the future.
Yeah, in fact, when you building up a strong connection between the regional bars, the bar association's role is very important. If we all can go through the official channels like Bar Association or Colombo Society kind of official channels, it's very easy to build up that connection between in the region. So at the same time, we now, for example, I think
Human rights law.
yeah, Human Rights Law Network. So as I said earlier, in 2013, just after the impeachment struggle, we were able to build up very strong connection between Indian bar and certain non-organizational, non-government organizations in India. So because now it's also part of the activism. It's also part of the activism. For instance, now this Palestine campaign is concerned. Recently, we were able to go to Malaysia for a campaign. So when we were attending that campaign only, we were able to build up a lot of connections with the other regional countries. So likewise, always share it. So these kind of workshops and events will always helpful to do that. I think we should make use of that to build up connection between the regional institutions, individuals, and organizations.
Thank you. The questions? All right. Okay. Well, anyway, now we can open the floor for any questions from the floor. So from the audience, if you have any questions, yes. Please keep your questions to the point, and in the interest of time, we have the mic there. Anyone wants to ask a question? Or even any suggestions, because especially we are talking about, how to build the solidarity and, to strengthen the network, especially regionally. So even if you have any suggestions, maybe we could just share. Looks like the two speakers have given so much, like insights and knowledge.
No, not that. Everyone's thinking, I suppose. See, you've set a very good example in Sri Lanka now by calling this meeting after many, many years. This initiative is coming, I think, maybe 7, 8, 9 years after the first steps were taken in Delhi. So think of how we can go ahead so that we don't leave Sri Lanka tomorrow, that this is just another conference where we learn something and we discussed. I have a sense that if we connect right across this region, even if you do South Asia, you would have a network of 100, 200, 300 lawyers easily. Easily. And then how do you do every year a kind of a conference and train people in human rights law? So just think of an idea how to cement what we are doing today. Take it forward. It's a very important thing you've done. For me, standing from outside, coming here, it's a very important thing you've done. And I suppose if you do a meeting in Nepal again, there'll be so many people who join, or the Maldives. Bangladesh, of course. So you already have potentially a network of at least 200, 300 people. That's huge. So just think about the future, that's all.
I have a question. So this is a very personal question of mine. I'm here. So the years of this activism and the lawyering and pro bonos and everything, and have you ever come across that this a spark of the enthusiasm or passion is facing some challenges? That means the inside of the activism as a person, then how you just overcome it?
It's the best profession. I tell you, it's the best profession.
Okay.
That you have a victim.
Okay.
That victim has no help. That victim doesn't know where to go. That victim doesn't know who to talk to. That victim is totally down. And as a human rights lawyer, you reach out and you work with the person and fight the tyrant. When you sleep at night, you get sound sleep. You may not get so much money for human rights work, but you get, no lawyer in this country starves. Nobody starves. You'll earn less, maybe. You'll do so many pro bono cases. But you will never get in your life the satisfaction of fighting a bully. That bully thought that this woman is alone. Whatever the case may be, domestic violence, rape, anything. He thought she was alone. And then suddenly you have landed up. And suddenly you're doing a case. And suddenly you're appealing to Supreme Court. You understand? That satisfaction which you get, we don't do this because of social. I don't do because of social work. I don't do because, it's good to do. I don't care what is good, what is bad. I do because I am selfish and I get tremendous joy out of catching a bully by the neck and shaking him up through the law. That is what we all do. And that is the repayment we get for our soul. It's a spiritual thing. Nothing to do with law and this and it's spiritual fight. That you thought you're a very powerful person. It's a fight of the spirit. That no matter how weak I am, poor I am, woman, man, whatever, however weak I am, the spirit wins. All it needs is a little help. Little touch it needs. It's a spiritual fight. So no one can defeat. If it's a spiritual fight, nobody can defeat you. Because you're not bothered. You're not afraid. You're not going to retreat. You're not going to say sorry. So at some stage, the bully realizes this is a powerful force. Maybe financially weak, maybe economically weak, maybe, crying, suffering, but not giving up. We never give up. We never give up.
Thank you.
I just want to add something to that, actually very important point. So once we become lawyers, actually from the society, from this market economy, they always want to convert us to a consumers. So first instance, we are going and take a lease, then take a big loan and build a house, then have a good wedding. It's flourishing with a lot of things. Once you trap to that, it's not easy to be an activist, be a fundamental rights, because you are committed. I just want to tell this, the Chunnakam case, Ramsirasik case and Kalukele case, cases which I appeared, all three cases, I appeared pro bono. Sometimes in Chunnakam case, I only paid for photocopy and other stationaries. I think most of here, I know Lakshan also like that, you were chairman. So that's the nature. So most of fundamental rights cases we are doing pro bono, around 75%. So as Colin said, the satisfaction out of that you cannot gain even after doing a case which you charge 1,000 millions. You can't get that satisfaction from cases with corporate clients or other multinational companies. So do work for that satisfaction. So that is what you can give to this society.
Thank you so much. Yes, we will never give up, and we need to thank you, Colin, for reminding us to be Davids to fight with Goliaths. And I think we have to continue fighting, and that satisfaction is something that really gives us a lot of peace, and we cannot measure it by money. So thank you for giving that great insights, and with this we will end this session, and on behalf of the Human Rights Committee, I would like to thank the panelists and also the audience for joining this session. Over to you, the compeers. Thank you.
Once again, I would like to thank our distinguished panelists and the moderator for concluding day one with such an inspiring discussion. With that, we conclude the first day of the Learning from Our Neighbours Conference 2025. We extend our sincere gratitude to all our speakers, moderators, and participants for their contribution towards the day.
Let's give a huge round of applause to all our esteemed guests and participants, panelists, for these wonderful thought-provoking sessions. We look forward to welcoming you all back tomorrow morning for day 2, where we will continue these important conversations on human rights in South Asia. Thank you and have a pleasant evening.